Yes, my name is Robyn White. I'm a PhD candidate at the Centre for Alternative and Augmentative Communication in South Africa. And I would like to acknowledge my supervisors, Professor Juan Borman, who's the same professor as Amanda, and Dr. Ensa Johnson. And I just want to thank my funders quickly in the beginning, the NIHSS and SAHUDA, and the University of Pretoria in South Africa. So I just want to start this presentation off introducing Martin Pretorias. He is a South African author. He's written the book called Ghost Boy, and I know it has been translated into Swedish, and I really recommend, if you haven't read this book, to read this book. And when Martin was about 11, he became very ill, and I think he was ill for a very long time, nearly a year. And one of the results of this illness is that he lost his speech and he became nonverbal. And he speaks very descriptively in his book about the abuse that he encountered, and more specifically, the abuse he encountered by someone that he knew, his caregiver, someone that he trusted. And I just want to read one quote that says, "There were times when I wondered if she scared herself with her own violence. And he knew that he couldn't say anything. She knew he couldn't say anything. And the violence actually continued for many years until eventually when he had an assessment at the centre in South Africa and was given alternative means of communication." And so this is just to paint the picture that this is a really serious topic and we need to address it and we need to speak about it because there are many other people like Martin in care homes and the same things are happening. So my aim of my presentation today is to discuss my master's research, which is finished, where I looked at vocabulary that was needed to testify in court. And from the recommendations that came from my master's research, that is what led me into my PhD research that I'm currently doing. So I'm looking at accommodating persons with severe communication disabilities in court and using universal design principles to guide key role players. I just want to make a note that this is based in a very South African context. My master's research was done in South Africa, and my PhD research, even though I will be having an international expert panel, today I will be speaking mostly about the South African research. And to highlight that as beautiful as South Africa is, and I'm proudly South African, it is a country with very limited funding and limited resources, and we really struggle in this area. So a brief literature review, and I know Amanda and many of the other presenters have gone through this today, so I'm not going to take too long on this. But I just wanted to mention that accessing the criminal justice system is a basic human right that is protected internationally by the Convention on Rights of Persons with Disabilities, and that the CRPD includes children with disabilities. And the CRPD furthermore goes on to highlight in Article 13 access to justice. And under access to justice, they state there that all state parties should ensure that there is effective access to justice for all persons with disabilities on an equal basis. And then they furthermore go on to state that all state parties should promote training for all key role players that are involved in the justice administration. So police officers, investigating officers, attorneys, prosecutors, and excuse my legal terminology, but in South Africa we have a prosecutor who fights for the victim, we have a defense attorney that is for the perpetrator, and then our judge is normally called the magistrate. So I'm sorry if that confuses anyone, but just ask if you need clarification. And obviously today we've spoken about how research has shown that persons with disabilities are at high risk of being victims of crime, and they are often repeat victims because they sometimes cannot verbalize the victimization, and that persons with communication disabilities are even more vulnerable than other persons with disabilities. As seen in Martin's case, and research has shown in many cases, most of the time the perpetrators are known. They are caregivers. Within the South African context, it's the perpetrators. Many times the victim doesn't want to disclose because the perpetrator is the main breadwinner. They know that if they go to the police and they try to tell someone that this person did this to them, who's going to buy food tonight? So it's a real big issue within the South African context. There are a chain of events that contribute to persons with communication disabilities becoming increasingly vulnerable as victims of sexual abuse. One of them being obviously the risk that they can't shout or call for help when the crime is happening. There's a lot of self-blame, and many times they think, is it something that I did, that this person did this to me? Will anyone believe me? Will anyone understand me? And I don't know anything about the criminal justice system, so is it even worth disclosing this abuse? And another thing that many times the perpetrators believe, well, this person has no speech, so they won't be able to give a statement and they won't be able to testify in court. Within South Africa, our Department of Justice says if you have been a victim of crime or victim of violence, there are certain steps you should take. Go to your nearest police station, give a statement to the police, be prepared for court. We have court preparation in South Africa, and then go and testify in court. Now, for an able-bodied person, that is already a very stressful and traumatic process and steps you have to follow. Now, imagine you're a person with a communication disability, wondering, are the correct supports in place? Is there someone that will be able to understand me? And so persons with communication disabilities and their families find these steps even more overwhelming because they feel they will not be offered the support and resources to fulfill these steps. And once again, many times these cases go unreported or undisclosed. So extensive research is showing on an international level that criminal justice system professionals do not know how to communicate with a person with a communication disability, and therefore the crime often goes unreported or even undisclosed. So what I briefly want to speak about now is my master's research. My master's research had two phases, a qualitative phase where I did interviews and focus groups, and a quantitative phase where I did a survey where they validated what my first phase results were. We looked at the vocabulary that was needed to testify in court. We identified certain barriers and facilitators within the South African criminal justice system. And then what we did at the end, because we believe in knowledge translation and giving back to the community, is we actually designed a board for testifying in court, and we gave about, I think, nearly 500 to our National Prosecuting Authority, where it has not been used to testify in court in South Africa, but the prosecutors are using it as a guideline and a resource to be educated in terms of communication disability. And there are the three publications. If anyone is interested, please, I do not mind emailing it if you would like to read those. So this was an example of the communication board that we gave to our National Prosecuting Authority. And I just want to highlight here the categories that came up prominently in our research. When you testify in court, exactly to how you would disclose the abuse and give a statement, you have to say who did it, when did it happen, where did it happen, how did it happen, and what was used. So once again, this is very much for the South African context, but this can really be used as a guideline when we are assisting these victims to be prepared for court. When we looked at the barriers and facilitators in the research and what the participants were saying, we decided to use the ICF, which is the International Classification of Disability and Health, to group our themes. Because what we wanted to do is we wanted to look at the person, how they can participate in their legal process, and what were the environmental factors impacting their participation. So we looked mainly at the environmental factors, and these were the factors that we looked at. I'll speak individually about each one. Products and technology. Many of the participants were saying there was a need for an assistive communication kit and need for low technology communication aids. Within South Africa, we have 11 official languages, so many times we need an interpreter. But many times these interpreters are not trained in the field of disability. So what they were saying is, can we have a kit that's ready and available at the court so we can briefly look at a document that's explaining who this person is, what is the disability, and how we can communicate with them. And also to introduce low-tech communication boards in the training sector so people would know what is pictorial support, or what we call it in South Africa, AAC. The natural environment. If we can just remember that South Africa, once again, is a very limited resource country, and So when we say consider alternative court context, we've heard an awful story of a victim that was gone through the court preparation phase, went to court, and when she was sitting in the waiting room, the perpetrator walked in and sat right opposite her. And there she had to look at this perpetrator. She's already anxious. She's already terrified. It's a traumatic event. And there's the person sitting across from her that did this awful event. And so we really need to focus on considering alternative court context where this person can testify in a separate room with CCTV and suggestions like that. Prioritizing cases that involve children with disabilities. I'm not too sure about the process here in Sweden, but in South Africa, sometimes it can take 6 months to a year for the court case to actually happen. And we need to start prioritizing so that these children can start getting the relevant therapy and putting strategies in place to move forward. Allowing appropriate questioning strategies. And many of the defense attorneys do not like this. But once again, our research and what we believe is we are rooted in the human rights framework. And it is that person's human rights to be accommodated and to be able to testify in court. So we believe that allowing appropriate questioning strategies that are not complex, asking one simple phrase question, should be allowed. Accepting different communication modes. The issue with communication modes within South Africa is that a person can use a communication board to testify, but the accused and perpetrator's right is obviously to cross-examine. And so how does someone be cross-examined with a communication board that has already have suggested vocabulary? We are doing research on that as well. And then within South Africa, and I'm not too sure in Sweden, we have very urban areas like Johannesburg and Cape Town that's built up and there's lots of funding, but then we have very rural areas that there's no funding. And I'll give you an example later about how some of our courts are just not adapted whatsoever for wheelchair accessibility for nothing. Support and relationships. It's very important to provide comprehensive support. And I think the most important thing here, and from the research we got, is that the person with the disability is believed. That when they tell their story, they are believed, and that they're supported by a range of supportive persons, the social worker, the police officer, the court preparation officer. And within South Africa, this was an issue because of the lack of funding and resources to differentiate between a sign language interpreter and an intermediary. Many times, the victim becomes very attached to their sign language interpreter, and so then the social worker or prosecutor will say, well, let's just use them as an intermediary. But we all know that that has huge implications for the case, and the defense attorney will have a field day with that. Attitudes. To dispel myths around sexuality and disability. Within South Africa, there are many myths about sexuality, that people with disabilities are asexual, that they are oversexed. There's even a cultural belief that if you sleep with someone, if you have sex with someone that has a disability, that you will be cured from HIV. And we really need to have training around this area, and that's to change the negative attitudes with training. Because there's also many attitudes when the person with a communication disability comes into the police station, the police officer says, well, I don't know if this person can testify in court, so what's the point of getting a statement? And we know that the case cannot go forward if we do not have a statement. One of our PhD colleagues who's just finished her thesis actually did wonderful police training in one of the provinces in South Africa, and it has had really positive feedback of police officers saying, wow, I mean, I understand more about communication disability now. I know how to take a statement from a person with a communication disability. So there is a lot of positive feedback if we can train the police officers. And then services, systems, and policies. Training disability and communication across different levels in the criminal justice system. My current research is saying, yes, we do have to start at the ground level, which is the police officers. But what about the court preparation officers? What if you prepare this witness for court and you get a magistrate that says, no, I'm not having this person testify in court. I don't know what this is about. So we need to be able to train on all different levels. Within South Africa, we do court preparation, and it is law that you get to use an intermediary. But not many legal professionals know this. And so once again, we need to be able to train. specifically within South Africa, there is sometimes not a lot of collaboration within our different departments. The Department of Justice comes and says to us, no, this is the Department of Health's problem because this person has a disability. And then the Department of Health says, no, this is the Department of Social Development's problem. And so we really need to work on the collaboration of the different departments in the criminal justice system. And a big move in South Africa at the moment is law reform. We have many different laws, one of them being that a person can only testify viva voce, which is using speech. And there are many advocates and civil groups that are trying to push this law away, saying no. It is a person with a communication disability's right to be able to testify, and we must be able to accommodate that person. So we're very happy that there's some law reform happening. So this is my PhD study now. I have 5 data sources in 2 phases. This is my first data source. I did a South African expert panel discussion. You'll be happy to know I will be doing an international panel discussion later in the year. But these are just some of the results that we got in terms of court accommodations that could assist people with communication disabilities. So the aim of the expert panel discussion was to describe and identify court accommodations. And then there were 8 experts with an average of 23 years experience in the legal field. This is just an outline of the experts that were involved. And I just wanted to explain that you'll see there's clinical psychologists, there's one of our state advocate prosecutors, associate professor in law. Within South Africa, if you have a communication or an intellectual disability and you have been a victim of crime, you get referred to a clinical psychologist. That clinical psychologist has to do a psycho-legal assessment, that they make a report, and that goes to the court to say, yes, this person is competent to testify, or this person is not competent to testify. So you will see I have many clinical psychologists that have been doing this for many years. But I would like to focus on expert 3, who is one of our state advocates and prosecutors in South Africa. And she was one of the first prosecutors to take on a case with a victim with a communication disability. And this victim had been abused for many, many years of her life. And when it went to court, the perpetrators pleaded not guilty because they thought this person, she had never been literate, she had not been taught to read and write, and there was no way that this victim could testify. She didn't testify, but what we have in South Africa is something called the victim impact statement. And luckily, this prosecutor knew how to find the right experts in the area in South Africa, and she was able to give her victim impact statement using pictorial support to the magistrate, who accepted that as a form of evidence. And the perpetrator went back to one of the perpetrators and said, I just want you to know that we're going to use this in court. And that perpetrator changed their plea to guilty, and they got 20 life sentences. So that is the advantage, and that is the power of sometimes using pictorial support and allowing and accommodating for people with communication disabilities to participate in their legal process. So the results, we use the CRPD as a human rights framework. And we focused on Article 3 and Article 13, access to justice. And these were the 7 themes that were identified, and I'll explain each now. And I will just read you some quotes that the experts said under each theme so you can understand, so there's context. Accommodations and accessibility. The one expert said there needs to be non-verbal ways of communicating that are reliable and valid. And obviously, this has to be on par with the law. We need to ask for intermediary services because many people in the rural areas do not know that it's that person's right that they could have an intermediary in court to help them testify. One of the things that we use, we've got a picture book that talks about how to do sex education with people with intellectual disabilities. So once again, coming back to how important it is to use pictures to be able to explain. Access to justice. They face a court that is unwilling to see that these are intellectually disabled people and that the courts and society should be adapting to meet their needs. Instead, the courts want these witnesses to meet the requirements set by the court. This is an unfair situation and has human rights implications. We know that this is a high-risk population group, and we see a lot of these autistic spectrum disorders children. And often the courts don't know how to deal with this. They arrive at the police station level and actually are turned away. That's a huge challenge because these children cannot communicate, and the investigating officer cannot extract information or extract a statement from the victims. And then we know that case does not go any further. Equality. Everyone is equal before the law and has the right to equal protection and benefit of the law. So our witnesses need protection, they need special protection, and we have to put systems in place to provide that. And then equality includes full and equal enjoyment of all rights and freedom. But the courts are set in their ways, and I believe are not accommodating enough to intellectually disabled witnesses. Human dignity and respect. Our court preparation officer actually had to carry that person in a wheelchair, that witness in a wheelchair up into the court, and somebody else brought the wheelchair up, and their dignity was totally shattered. And for them to testify before, and their dignity is destroyed before they can even get to testify, it was shattering. Just to highlight that the South African courts are an acquisitorial, adult-orientated system, and this causes challenges for child witnesses with disabilities because they are being compromised and they can only testify if they are seen to be competent. Non-discrimination. The courts expect them to meet certain standards that are unreasonable before allowing them to give their version of events. The courts seem to require a lot more of an intellectually disabled survivor of rape and sexual assault than really non-disabled rape survivors. So if I was raped tomorrow, I wouldn't have to go to see a psychologist and get a piece of paper that says to the court, right, is good to go. She can give evidence, and so these intellectual disabled rape survivors are subjected to this assessment, obviously, in order to determine their competency to testify. Participation. The other difficulty is that, so in South Africa, we have a truth and lie competency test, and all people with communication and intellectual disabilities have to do the test. The other difficulty is that truth and lie, it's an abstract concept. It's difficult even for me to stand in court and define. And we know that people with intellectual disabilities have problems with abstracting abilities. We know that they are raised and socialized very often to be very compliant to adult figures and authority. We know that people with intellectual disabilities have difficulties with self-protection and recognizing risky situations. And yet in court, we expect them to answer abstract questions that people that don't have intellectual disabilities struggle to answer. And in fact, philosophers can't even figure this out. Also, I have problems with this implicit message. And the last one, training. So the challenges faced, something that we are finding and we continue to experience on the ground is that police officers, because of the lack of skill, the inabilities and fears around how to work with this population group, they often turn them away, or they're given a very poor reception, and the way they're treated, it's almost as if the victim and the families of the child with a disability is treated as the perpetrator. We didn't know, and this is from one of the lawyers that were in my expert panel, we didn't know anything about disability because I think, as you know, lawyers are generally not trained on disability issues. So some of the recommendations were training assessors in legal matters and in communication disability can work alongside the court officials. And I think this is done in Sweden and in Canada, where we're really trying to push forward that the investigating officer's statement can be used as evidence in court. Allowing alternative means of testifying in court, such as pictorial support, always to use a court intermediary, and allowing experts in the field of communication disabilities in AAC to testify. And I just want to end off with this quote from Martin Pretorias. Treat everyone with kindness, dignity, compassion, and respect, whether you think they understand you or not. And this is so important when we speak about this topic and this research, because we need to treat people with communication disabilities who have been victims of crime with kindness, dignity, compassion, and respect. And we need to help them be able to get effective access to justice on an equal basis to others. Thank you. And that is references.